Have you ever wondered how laws are actually made? People always talk about legislation, the changes to come with an act or the law, but they never actually talk about the process and how long things can take. Well, this episode covers all of the details around how laws are made and also what laws are on the horizon and what bills you may expect to see being put into place. Hi everyone, welcome back to Lawlands. My name is Sanam and thank you so much for tuning in today. I am back. I am so excited to be back. For anyone that's listening that has no idea, I've actually been in Fiji for the last few weeks and I am so excited to be back into the groove of things and behind a mic. It is so exciting to be recording this episode because I really truly missed it. During my travels, all I could think about was, wow, it would be so great to even just be recording here and to be connecting and talking about the experiences that I've had. But I came back with a lot of ideas, a lot of stories, so I'm really excited to slowly start posting about them on LinkedIn. And with that said, if you haven't been following the podcast, then please absolutely give the podcast a follow. I will be releasing new episodes every week. That's right, weekly episodes on a Tuesday. So they have moved slightly to a Tuesday. I thought it would be better so that you can get into the groove of the week and then have the episode there for you on a Tuesday. And also jump over onto LinkedIn, give me a follow there if you want the latest tips, tricks, and insights because I'm constantly posting about new cases that I see, about legislative changes. So definitely jump over and have a look. But to this episode, as we're talking about legislative changes, it's very timely because we obviously know that laws get passed, but then we only hear about, hey, these changes are coming. We don't really know about what the process looks like or what happens. Or we hear that, hey, this bill has been passed now, and now you have to do this. And a lot of employers feel blindsided because they had no idea that it was leading up to that point or leading into that direction. This episode is solely dedicated to really understanding how bills are passed or how laws are actually made, and then also looking at what bills are on the cards at the moment. What is Parliament sitting there with at the moment that is a pressing issue that we may need to be looking at for further on down the track. So with that said, I wanted to cover off a few bills in a few areas, but before we do it, I wanted to get into Laughs with Lawlands, where I give you a dry joke in these episodes. I told my boss I was thinking of changing my job. He said, "That's fine, just don't do it here." I loved it. When I read this one, I thought it was hilarious because I know that we all have been there where we've been sitting at work going, this can't be it. There has to be something on the horizon, a light at the end of the tunnel. I need to move towards something. So I thought, yes, I've been guilty of this in the past. I do have to talk about this one. But hopefully your workplaces are happy enough that your employees are not doing this. And if they are, then that is a conversation for another episode, which we can definitely have. When it comes to how laws are actually made, it's interesting because the way that the process is actually designed is to allow for debate, for scrutiny, for maybe even changes and potential amendments. And the way that the process goes is that first you have an introduction. So the bill is introduced, it's made public, and it's announced in the House. And it has no formal status until the introduction point. So once it's been introduced, it's formally there on the table. Now, once it goes through the introduction, the first barrier it needs to pass is the first reading. And this is the first debate that occurs. And it usually occurs no sooner than the third sitting day after the introduction. And the whole point of the first reading is that members get together and they debate and they vote on whether the bill should move forward or not. If the bill gets defeated there, then that's where it stops. But if there is some merit to it, then it goes and it moves into something called the Select Committee. Now, the Select Committee is the next stage, and that has around 6 months where the committee can actually review the bill. They can invite public submissions and they can hold hearings and recommend changes. So, for example, if we look at the Holidays Act at the moment, we can see that even though there is an amendment happening to the Holidays Act, it is going through a period of getting recommendations, of going through a period of review, and in September, we're we're going to see what those recommendations and all of that information gathering has led to. So that's usually how it would work. And then with the select committee, their report includes the amended bill and then the commentary as well. So once it passes through the select committee and they've had a look at that, it goes through the second reading. So when the select committee has presented their commentary and their report and all of that information, then it goes through the second reading, and that's where members debate the bill's main principles and the committee's recommended changes. So they really sit down and they have a look at, okay, is this serving the purpose that it's meant to serve? And what changes have been recommended by the committee? Is this right? And then after that, so you can see this is a long process. Then after that, it goes to the committee of the whole house. And this is where all members can participate in a less formal but a detailed debate and propose further changes. So this opens up the floor to everyone. They sit down, they have a chat, they talk about it, they debate, and there's no time limit for this. And the final form of the bill needs to be agreed upon and then reprinted at this stage. So this is where it can drag out. It can take quite a long time. Even at that, a 6-month marker as well that I just mentioned, when we were looking at that, that also can take quite a lot of time. So that's where things can drag out when it's at the select committee. So after the committee of the whole house, where there's no time limit and the final bill has to be finalized and presented, that's when it finally reaches its third reading. Now, when it reaches its third reading, that's where we're looking at a summation of the debate. We're looking at the bill in its final form, and we're doing one final vote if it gets passed or rejected. And if it gets passed and everything's all good, hunky-dory, then it moves to royal assent. And once it gets to royal assent, that's when we've got the sovereign or the governor general signing and saying that this is now an act that has been put into place by Parliament, and it's a transformation basically of the bill into an act. So it is a process, to say the least. And with stages such as the whole house, you can see where it can take a lot of time. And no one ever talks about bills unless it's something major. So like with the Holidays Act. But there are a lot of bills that sit at Parliament. And we'll have a look at some of them today that I thought were bills of note, that I thought would really make a huge impact in a majority of workplaces. There are some that are sitting there that may make an impact here and there in terms of slight changes and slight variations to workplaces. But these were the ones across the board that I thought really mattered. This particular bill that I wanted to talk about is to do with the restraint of trade. Now, the Employment Relations Act may go through a set of amendments and changes around restraints of trade. This bill was actually first introduced, you ready for this? 22nd of September 2022. So it has been a while since it's been introduced. It is, as of the 26th of July this year, at its second reading. So it is now at that second reading stage where the select committee has presented their report and the members are debating on the key principles of the bill. Now, you may be wondering, what is this all about? Well, we know that restraints of trade are used by a lot of employers across New Zealand, and I would say in a lot of cases, not done particularly well and correctly. Also, slightly maybe veering on the unethical as well. Not to say that every employer is unethical, but we do see that happening a lot of times where employers are trying to say, look, I don't want you to work for anyone else. I don't want you to take all of my trade secrets. A lot of times it's misinformation and not understanding that other parts of the legislation, other parts of the employment agreement can actually protect that employer. So what we're finding more and more is that employers are trying to slap in a restraint of trade and hope for the best. What the problem is with this practice is that it's frequently challenged in court and it's found to be unreasonable and also unenforceable on the part of the employer. It also is legally very costly. You're trying to make these people comply with unenforceable restraints. You're battling it out. And also what ends up happening is that it results in a lot of lower paid employees being the ones that get stifled because they don't get to move around. So the objective behind the bill and the whole idea is to prohibit the use of restraints for lower and mid-income employees. So these are employees that are not the CEOs of a company. They are not the CFOs. They are not there as the major movers and shakers of the company. They are the people that may be working at front of house, or they may be the salesperson at a particular retail store. They are not the ones that should be bound and tied to a restraint. Now, it may seem like, look, this is just general knowledge and this is just general ideas in Sanam. People shouldn't be doing this. You're absolutely right, but it still happens. And it also is the objective of the bill to require employers to consider the appropriateness of a restraint when it comes to higher income employees as well. If you are putting a restraint on them, then how appropriate is that? And do you need to compensate them for that particular restraint? It's not ideal to be paying compensation, but it is trying to create unique circumstances where these restraints are being used. And like I said, sometimes it is a misinformation or an overlap that exists that employers don't realize. Like, for example, they don't want confidential information to be passed around the workplace or to go to someone else. But that's where your confidential information clauses can come in. And a lot of times, a non-solicitation can be a much easier or more palatable clause rather than focusing on restraining their trade or being able to work for a competitor in that capacity. So in terms of the details behind the provisions in this particular bill, there is a restraint where it affects particular income earners and creating a framework of when restraints are allowed so that an employer, they are only able to restrain an employee where there is a proprietary interest to protect the employer. It's really important because we don't really have an extreme threshold at the moment, which is set out in legislation, which is very clear. Then the last thing in terms of what the bill allows for is compensation. If the employee needs to be restrained, then the employers must pay employees subject to the restraint of trade an equal amount, which is half of the employee's weekly earnings for each week the restraint is in effect. Now, that is a very contentious point. To have to pay for the employee to effectively be restrained for a higher level employee is the contentious part. And that's where I would say that it will be quite detrimental to a lot of employers. On the flip side, though, if an employer chooses to use this and they really believe that it's to protect their business, then they effectively are paying to protect their business. Then the last component is the duration and the time limit, capping that at 6 months. We see a lot of restraints where people are trying to do it for up to a year. And now with the fact that the employer may need to pay, capping it will be quite a beneficial thing. Now that is the restraints related changes. The other change that is coming up, or in terms of a bill, we don't know if it's going to be 100% passed or not, obviously, is to do with remuneration disclosure. So this is again amending the Employment Relations Act, but it's to do with remuneration disclosure. And we have actually seen pay secrecy laws and all of these things in Australia. And I wouldn't be surprised, because we're headed in that direction, that we're going to see this as well. This was introduced on the 20th of March this year, and it's at its first reading. And the whole purpose behind this is to protect employees from adverse actions by their employers if they want to inquire about or discuss or disclose their remuneration information. And in terms of what the purpose behind the legislation, similar to why Australia has done it, is to promote transparency, which allows for there to be fair and equitable compensation practices. It also protects employee rights by safeguarding them from retaliation and negative treatment from their employers. And the purpose behind the bill, they say, is also to support fair treatment in terms of making sure that the employees can freely discuss their remuneration without fear of losing their job or facing some sort of discrimination in the workplace around maybe conditions or opportunities or benefits that they would get. Now, if you ask me, in terms of whether this is going to be a beneficial piece of legislation or not, I can see the merit behind it. Like everything that's been listed out and the purpose that they've said, it makes sense. It creates fairness in the workplace and market in terms of everybody understanding where they're at. But where I see there being an issue is if we look at large business, large corporates, where people are looking at diversity, equity, and inclusion. But when we're looking at small business, it's a lot different when you start talking about pay secrecy. And I think that's where the discussion has fallen short. The discussion around pay secrecy has always been around it's going to be fair for everyone to know what they're getting. But I think a lot of people don't realize that with small business, what ends up actually happening is you have, for example, a lot of times people, if they know in a small business what everyone is getting, it can create a lot more hostility in the workplace, and it can create a lot of difficulty in the workplace. So it doesn't always work to the benefit of the employer. It can also be detrimental. I've also seen many times employees that get pay increases because of the minimum wage increasing, that there is an expectation that everyone on a normal wage that's well above minimum wage should also get an increase as well. These expectations are created by discussions of pay, and I understand that having the discussion can be very transparent and open and it creates fairness, but there is a downside to it, which I believe should be part of the discussion. We should never leave both sides of a discussion out. In terms of what the legislation will allow for is mainly that an employee can raise a personal grievance and they can say there's been adverse conduct related to a remuneration disclosure. So that means that if the employee gets dismissed or even leading them to a forced resignation or retirement, that can all contribute to that. But we'll see where that's at. It's only at its first reading. It's got a long way to go. But if it's anything to show that we are moving in Australia's direction, then most likely this is something that will come into place. Now, in terms of another bill, which is amending the Employment Relations Act, it is actually protection for KiwiSaver members. I was really interested by this solely because I didn't realize that this may be something that's actually happening in the workplace that needs a little bit of attention. And this bill was actually introduced on the 8th of June last year. It still has a while to go, but the purpose behind the bill is that it actually allows for KiwiSaver members to be protected from potential discrimination, making sure that they actually receive fair and equal treatment in their employment. It provides safeguards that were removed in 2008 to prevent discrimination around maybe their KiwiSaver contribution, around equal treatment of KiwiSaver members in terms of employment conditions and benefits, and it also prohibits employers from offsetting pay increases against KiwiSaver contributions. And that will be looking at adding in a new ground for a personal grievance claim to adverse treatment due to KiwiSaver membership. And the whole idea is that the criteria specifies to determine if an employee has been adversely affected due to their KiwiSaver membership. So it is going to be a little bit of an interesting one in terms of pulling this out in a case. How do you actually show that there could be legislative gaps there that did cause workers to stop saving for retirement, to inhibit them from getting specific protections? And in 2008, the law looked a lot different. The protections were in place and then that was removed. So this is aiming to bring that all back. Keep an eye out for that. And the last one that I wanted to talk about that I thought was really interesting, and like I said, this is by no means all of the bills that are sitting there at the moment. I know a parental leave one was just recently announced a couple of days ago, but these are the ones that I thought would be really impactful for a lot of employers. On the 6th of April last year, it was introduced, and on the 30th of August, it actually went to the Select Committee. So we're seeing this move quite quickly. This is an amendment to the Crimes Act, and it's actually to do with the theft by an employer. This is really major. And the reason why I say it's major is because for the longest time, if an employer didn't pay their employees, then yes, they would need to pay potentially compensation in terms of a remedy at the employment courts. They would need to potentially pay wages in arrears, also have a look at lost wages depending on how the employee's future employment goes. So all of those factors would normally need to be considered as remedies. But now what we're looking at is that if an employer chooses not to pay their employee because they end up maybe saying that, look, we just can't pay you right now. I've done posts about it in the past, and there's definitely one that I've put out there about Fiji and wage theft, which I think you should have a look at. And it's about migrant worker exploitation. But those cases are the ones that are going to be really interesting because we see this happen too often. And what it will do is amend the Crimes Act to allow for employers to have harsher penalties effectively. If there is a non-payment of wages, an intentional non-payment of wages, so keep that in mind. It's not just because there's been a payroll error or something like that. I have definitely seen worst case scenarios where the employer has blatantly said to me, I refuse to pay them, not because the person is a bad employee, but maybe because they're going through a difficult time and they think that not paying the employee is a way for them to get money in their pocket, but the business is still running, the person is still working. That's not okay. Like I said, that post about migrant worker exploitation, I think I really hit the nail on the head in terms of how employers must feel during economic times, having difficult customers, and also dealing with difficult difficult employees, but that shouldn't bar an employee from getting their minimum entitlements. And what's really important is that this piece of legislation will now up the ante when it comes to non-payment of wages, and the penalties will include for a person up to 1 year of imprisonment and a fine of $5,000 or both. Also, for other entities, it will be a fine of $30,000. It's serious. If you are not paying your employees, the risks are a lot higher now, and it is really important that you do right by your employees, because the last thing that you want is to be slapped with this kind of fine or even imprisonment. Could you imagine going to prison for a year because you chose to have a battle with an employee where you didn't pay them intentionally? Now, of course, it will need to be proven that it's intentional. And a lot of times what comes out in these cases is text messages where the employer says, you don't deserve anything, I'm not paying you a single cent, or something like that. And that's where you can usually see, or the employer choosing to ignore or agreeing with the employee to pay them and then not paying them and delaying the payment every week, every month, whatever it is. So those are usually where we see those cases. So those are the key bills, like I said, that I saw, which I thought, hey, we need to have a chat about it. This is what I can see on the horizon that will impact a lot of employers. And keep in mind as well that the Holidays Act and also the workplace health and safety legislation, all of that is changing. There is a massive undertaking there in terms of what needs to be changed, but we don't have the exact dates yet. I just wanted to say thank you to everyone that has been following the podcast, that has been reaching out, connecting with me on LinkedIn. It is lovely to meet you all, and I love the fact that we are creating the best community here ever. I hope every time you tune in and you listen to this podcast that you feel like you are harnessing employment relations in your workplace, that you are understanding it a lot more, and that you are gaining a little bit more confidence every time, because that is my mission. I want to make employers, HR professionals, people running their businesses feel more confident and empowered in the workplace. Now, for everyone, thank you so much for giving me your time. I really appreciate it. I hope that you've been following, and if you haven't, definitely give us a follow and subscribe to the Lawlands newsletter. I am so excited to do this outro. Thank you so much, everyone. I hope you have a lovely day, night, evening, morning, whatever it may be. And guess what? I'll catch you in the next one, everyone.